on the book Best in Class by Gary Lipsky and Kyle Mitchell. This is chapter 6 about legal. There's a famous quote, "A law is valuable, but not because it is a law, but because there is right in it." Now, my first key takeaway is have an attorney on my team. Second, more likely than not, I will have more than one attorney. Third, if I do syndications, I will need an SEC attorney. SEC stands for Securities and Exchange Commission attorney to draft my PPM, or also known as private placement memorandum. And these are the documents, and this would keep me compliant with the SEC. Fourth, I will need also a real estate attorney, a real estate transaction attorney to help me advise on all the contracts outside of the SEC filing, such as the purchase and sales agreement. Now, fifth, I will also want an asset protection attorney on my team. So there's several different attorneys, from SEC attorney to a real estate transaction attorney to this attorney, which is an asset protection attorney. Six, know my private placement memorandum. Why? Because this is a legal document provided to my prospective investors that describes the company selling the securities, the terms of the offering, and the risk of investment. Now, the PPM, or the private placement memorandum, in and of itself is kind of worthless. I can just pull one out from the internet or use a template. Now, this is the key. It's what's inside the PPM, the document, that is important. It is what's inside that's important. I should be working very closely with my SEC attorney to make sure all the information in the private placement memorandum is written as I intended it to be. Example, the difference of this one word, return of capital versus return on capital. One word can make a huge difference. The return of capital and the return on capital has to do with how I pay back my investors and track their capital accounts for balance. Now, let's say if the capital account or balance is reduced, then it is a return of your capital. Now, if my investors are receiving distributions from the cash flow of the property, then it is a return on capital, and that is tax-free, the return on capital. Now, if my PPM or private placement memorandum say one thing and I am doing another, I am not compliant with the documents, and therefore understanding the private placement memorandum is important. Seventh, typical syndications hold onto the deal for several years. So remembering everything in a PPM is very difficult. It's a very difficult thing to do, if not impossible. And this is especially the case if I have several offerings over the course of multiple years and have to adjust some of the terms between each offering. It is important, therefore, to keep referring back to my PPM or my private placement memorandum, especially when I am asked a question by an investor and when I am sending out specific communication. This helps ensure that I am conveying accurate information and that I'm following guidelines set out in my offering. 8, this private placement memorandum is a binding legal document, and I am responsible for making sure I follow it accordingly. 9, the juicy part, which is advertising, and this applies to 506B, 506B offering. There are two types of indirect advertising that will get the sponsors or general partners in trouble. These types, the indirect advertising, are not as obvious and can be easily missed. Now, it's divided into two. when I have an active deal and when I do not have an active deal. Just because I do not know it was wrong or other people are doing it does not mean I can get in trouble for it. Does not mean I cannot get in trouble for it. That means I could get in trouble because of my ignorance or because I see people doing it. First type of indirect advertisement is when I have an active deal. For example, I might be talking about due diligence and walking units with a property management company. At this point, it is okay. I'm fine. But when I start bringing up how everybody knows I'm raising money, now I am indirectly advertising, and this can be considered conditioning the market. The second type of indirect advertising is I also need to be careful of advertising when I do not have an active offering, an active deal. This is an indirect advertising that gets people into trouble. Most people think that as long as I do not have a current deal, I can put anything on social media or send out emails. This is preconditioning the market. 12. One of the most common forms of preconditioning is post-closing post. This is the one where everybody creates and everybody celebrates, and say, hey, I'm super happy to announce that my team and our investors have closed on this amazing property. According to the authors, there's two issues with this. One, if I am continuously raising money after I make that post, the deal is not done. Some people close on deals, but still need to raise an additional, it could be 50,000, 100,000 or more. And this may not happen for another week or month. And if this is the case, the celebratory post, the congratulation post is called preconditioning the market. And that creates problems for me regarding the money raised after the post. I have advertised the deal that lasts 50,000 to 100,000 is a violation of the 506B boy offering. Now, if I have another deal just around the corner, this can be considered preconditioning the market. 13th, another example of preconditioning is this. I went on a podcast and said, I have gone full cycle on several deals. In the past, we have given our investors 50 to 20% returns. So you should call me. Just because I do not have an active deal does not mean I can tell people types of returns I provide or have provided in the past. When it comes to advertising, there is a ton of gray area. The key is this, to truly come from a place of adding value to others. It is not indirectly selling my deal. 16, there is nothing wrong with me making a post on social media. Nothing wrong that says, I wrote an article about why multifamily is the greatest asset class of all times for creating wealth, or why Florida is the greatest market right now. 17, there is nothing wrong with hosting a webinar why real estate is so great. I can do this as long as I'm not talking about a specific deal or deals in general. 18, pure value add. Pure value add is probably the best way to continue to build my list and talk about real estate with others. I'm going to get contact information from that post, from that webinar, and I need to follow the right steps to establish that relationship with potential investors prior to them investing in my next offering. 19th, asset protection. Two things that I need to keep in my mind. First, if I am hiring a third-party property management company, I recognize that as the asset manager or the owner, I am legally responsible. Now, for both the acts of the commission that the property manager does, therefore, it is important that I add the property management company to my insurance policy. Second, I may want to consider setting up a separate entity to hold the asset management. This entity would be different from the one that owns my share of the property. Now, when I do a syndication, I may own a small percentage of the deal. I want to make sure that my asset management company is different from my ownership company. So all the liability is at the level of the asset management company. So the liability is at the level of the asset management company. 20th, asset protection. It's a complex topic. I need to reach out to an asset protection attorney. 21st, closing out my offering. Once I have sold my deal and I really want to legally close it out, I really have to legally close it out. Now, each state has a different process where I file some type of dissolution document, a dissolution document that officially closes it. Now, I want to make sure I have done this, paid all outstanding taxes, keep some reserves for additional charges that may pop up. Most operating agreements require me to keep some reserves, and consider getting tail insurance coverage. A tail insurance, what is that? Tail insurance covers me for anything that happens once I have sold the property and closed down the entity. This covers me for things I do not know about. It covers me for the unforeseen and the unknown. 22, Form D. Form I file when I start accepting those money from the investors. I file Form D in every single state that I have investors. Now, there is nothing I need to do when closing out my entity. 23rd, the only thing I will need to close out is the entity in the state in which I am incorporated. The entity in the state in which I am incorporated. So there are situations where I may have registered the entity in a different state from the location of the property. The authors say they recommend not doing this unless there is a reason that your attorney, my attorney, did this. In this case, I have to dissolve the entity wherever I registered the entity. And typically, entities are set up in the state where the property is located. So those are my lessons learned